Then ask counsel in 121643 State of Kansas versus Alonzo Union to come forward to the tables.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Alonzo Union, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, you'll remember this is a case out of Wyandotte County where my client pled no contest to one count of mistreatment of a dependent adult. The only issue in this case has to do with restitution. There's no question about the underlying conviction in this case. And their union was assessed over $31,000 in restitution by the district court in this case. And again, there's actually also no dispute that Mr. Union owes some restitution. The primary disputes in this case on appeal were the district court assessing an unpaid nursing home bill as restitution from Mr. Union, and then deciding that half of certain unaccounted for ATM withdrawals and Walmart expenditures should be assessed to Mr. Union as restitution. So I'll take these things in order. The first assessment here was to the Riverbend Nursing Home for a little over $7,600. There was no particular dispute in this case that, for example, Mr. Union owes the nursing home that amount of money. Mr. Union agreed to that he had, when the adult in this case had gone to the nursing home, that he had agreed that he would pay that and that he hadn't. So that's not really the dispute. The question is that properly part of restitution? And our argument is no, that the only things that the charge in this case, the mistreatment of an dependent adult, was charged as taking property from the adult in this case.
Go ahead.
And the thing that hung me up about that is, wouldn't the obligation to Riverbend, the nursing home, wouldn't that obligation be joint for both the victim and for your client? And so the nursing home would have had the ability to assess the estate of Ms. Miller for that $7,600?
So I think yes. Again, we're not disputing, could the nursing home have had a civil claim against Mr. Union? Almost certainly. Could the estate have had a civil claim against Mr. Union in that situation?
The other way.
I think almost certainly yes.
I'm asking the nursing home has a claim against the estate for the services provided to Ms. Miller while she was still alive.
I think probably yes.
Makes sense to me too.
Yeah.
So why isn't that the same thing as taking money from the victim?
That just because it's not the act of taking, that's a separate claim. And the fact that Mr. Union allegedly took some funds or things like that doesn't transfer it. It doesn't make that every person that owed the adult in this that was owed money by the adult in this case a victim of this case.
But the only
That's
reason,
what this holding would be.
let's just take this joint liability thing and the liability against the estate. Seems to me that it's the crime that he committed. Reason why that liability would go against the estate. I understand he had agreed to pay it, but I'm taking that off the table right now. It just seems to me that the acts that he committed, which constitute the crime, create the liability against the estate of the dependent person. That doesn't seem out of the ballpark when you look at our case law on what we've allowed for restitution.
Your Honor, I guess my argument and what I think is the correct argument is he wasn't charged with malfeasance with regard to not paying the bills that he was supposed to pay for her. In fact, and I want to point out, when we look at what the Court of Appeals said in this case on this point, right, the Court of Appeals at page 8 of their decision said there was a causal connection between the crime and the unpaid waiver. Substantial competent evidence supports the district court's finding that Union caused the loss. Union's admission that he was responsible for the bill. That's true. The undisputed evidence of the amount of the bill. That's true. And then the investigator's testimony that Union was supposed to pay the bill as Miller's power of attorney. This wasn't charged as a violation wasn't ultimately charged as a violation of the Power of Attorney Act, was originally, but the district court made a specific note that you can be charged with mistreatment of an adult for violations of the Power of Attorney Act, but that's not what my client was charged with. He was charged with taking money from the adult. And there's no showing that, for example, there was like money that was taken, that was somehow earmarked or otherwise caused the estate to not be able to pay this bill.
Well, that was just going to focus on that. What does the record tell us about that? Was it that he took money so that the estate was unable to pay the bill, which I think might be a different factual situation than if it, and the inference I drew was that the estate still had the money, he just hadn't paid it, and he had a reason that he didn't pay it because of a dispute about one of the charges.
My recollection of the record of appeal is that, I mean, we don't have a lot of information. The information that we have from the investigator in this case shows all the sort of the debits and things like that. But as far as what resources the estate may have had that's the estate claim, right? That's why that's where it should be, is in the estate to make that decision. And the importance, I mean, you might wonder.
But going back to Justice Biles' point, if he had depleted for his own purposes, the estate, so it couldn't pay, then it seems like all we're doing is replacing taking the middleman, the estate out of it, and having him pay directly to the ultimate vendor for that loss. But I guess we just don't know that from the factual record.
I don't think we know that from the record. And even if we did know that from the record, it's still not the gravamen of the crime. And the problem, I mean, again, you might wonder, somebody might wonder, who cares? I mean, he admits he owes it. What difference does it make? It's a big difference to Mr. Union, because this is a restitution judgment against him, and he's going to remain on probation as long as he can't pay this restitution. If this was a civil judgment, then he's going to deal with that like a civil judgment, but it's not going to keep him under threat of going to prison probably for the rest of his life. So it's a big difference whether this is a restitution judgment or a civil judgment.
It's my understanding that, and tell me if I'm wrong, that the expenses, the bill at the nursing home was caused by Ms. Miller's independent need for nursing home care. So that's what created the bill, because the nursing home gave her that care, correct?
Yeah.
And it wasn't it wasn't Union's malfeasance in creating the bill. It was her independent need for care.
He went to
correct?
the nursing home and got nursing home care, and that cost money. And my client admits he had agreed he would pay that when he went in. And so he almost certainly owes that
As a guarantor.
as a guarantor.
Right.
But not as a part of this criminal judgment.
What part of the criminal judgment does he owe? I mean, under your theory, does he owe any restitution?
Sure. I mean, he agreed. And when you look at the district court's restitution order, there was purchasers from a liquor store, purchase from out-of-state purchases.
Those purchases that he directly benefited from, that he used for his own
Yeah,
purposes.
and for which
those-
there's evidence, he clearly did that. So I think I added up almost $4,000 that we are not disputing. We never disputed on the appeal in this case. I don't really think we disputed at the district court. But
Back to the, oh, sorry.
Oh, no, I was going to have him move on to interest, but if you have another question.
I just had one more question about the nursing home. During that period of time where she was receiving the nursing home care, where did Mr. Union reside? Or is that part of the record at all?
yeah, I mean, I'm trying to kind of remember, as far as I remember, he testified he still resided at the same apartment where he was living.
No evidence that he was, co-occupying or a co-resident at the same time while she was receiving care
At the
Or-
nursing home.
or received other benefits, meals, et cetera, from the nursing facility. Mr. Union,
I'm sorry, I interrupted your question. Can you say it again?
no other evidence in the record that Mr. Union received any benefits from the nursing facility?
No.
All those benefits went to the victim in this
The
case.
adult in this case, yes.
And am I correct that there's no evidence in the record that Mr. Union actually took the amount of money of the nursing home bill from the victim? In other words, it wasn't that there was money set aside to pay this and he he took it.
That's right. There's no
Or
evidence of
that
that.
he had promised to pay and didn't follow through.
That's right.
So my follow-up question is, in the form of a hypothetical, if I invite you to lunch and say, I'm paying, we go to lunch and the bill comes and I don't pay your bill, haven't I taken that money from you? Or maybe the question is better, why haven't I taken that money?
Yeah, because uh, it's the difference between an unpaid sort of debt being a creditor. And this, I mean, the hypothetical, I would go even farther is, let's say you and I go to lunch and I say, I'm going to pay the bill. And on the way there, I'm mugged. And you go to lunch and you pay the bill. And you say, oh, by the way, he was supposed to pay the bill, but he didn't have any money when we went to lunch. So I also want the robber to pay that. That's what this case is. And I think that's the better hypothetical. I'm almost out of,
And just one quick question. When he took responsibility for the bill, did he sign as DPOA or did he sign as in his individual capacity?
I don't remember it being in the record, like any documentation as far as that at that time. He testified that he agreed to that. And so I don't remember.
He was originally charged with violating the duty of a DPOA under the mistreatment of an independent adult, correct?
That's right.
But the plea was for a different subsection, which was simply duping them out of money.
That's right.
So there's nothing that would be related to the crime that includes a duty that he did not.
But that's exactly what the Court of Appeals relied on. It's exactly what it relied on. In my 42 seconds left, Your Honor, I will just point out on the rest of this, our main argument, maybe I can talk about it more on rebuttal, is that the district court and the district attorney in this case shifted the burden. That essentially the court said, we have a lot of, and there is a lot of evidence that there were ATM withdrawals and Walmart purchases. That's true. But even the state's investigator in this case said, we can't tell you whether that was used for the adult's benefit or for his benefit. I can't tell you. I don't know. And the district court in this case, and this is the Court of Appeals said in response to our argument that there's a shifting the burden of proof, the Court of Appeals said the district court's decision was not based on a lack of evidence. This is page 10 of their decision. The district court said at page 1 of its decision, but he has provided no documentation whatsoever to support this. That seems like the district court was finding that Mr. Union did not prove that he did not take these things. That's shifting the burden of proof.
Just one quick area I want you to cover is if we disagree with you and say there is a part of the restitution is the amount owed to Riverbend, what do we do with the interest that was tacked on to that obligation by the district court? Is that, are you arguing at all that that's separate and should not have been considered? I didn't see much of an evidentiary record to throw in the interest. I think it was 12%, and it didn't even come up with a figure, and the journal entry says 12% interest. Any argument about that?
So, Your Honor, and I'm kind of reviewing this here really quickly, and I'll look at it more while I'm sitting down, the order. I didn't raise any issue about interest in this case, although I know this court has cases right now talking about that. So to the extent that this court recognizes that as an issue and thinks separately, it would be appropriate to ask us to brief that some more.
That's fine. Thank you.
Thank you, Your Honor.
May it please the court, the state of Kansas appears by Ivan Moya from Wyandotte County. I will focus my argument on one issue, which is whether substantial competent evidence was used by the District Court of Wyandotte County when it came to determining the amount of restitution that was ordered. In this issue, there are two subsections that has already been referred to. The first being the amount of restitution that was ordered for the nursing home, and the second being the amount of restitution that was ordered in terms of the ATM withdrawals that were found to be done in this case. In terms of the nursing home, the amount of roughly $7,672 was ordered. Beginning in this issue, I would point to KSA 216604, which had been referenced in the brief by the state. Essentially, the language of this is the court shall order the defendant to pay restitution, which shall include, but is not limited to, damage or loss caused by a defendant's crime. And this is what we're relying on as a state. In this situation, it's very clear that the victim identified in the criminal matter was Ms. Miller. However, when determining restitution, this is the statute that would be controlling. When the restitution to the nursing facility was ordered, it was determined that there was a loss, a third-party loss.
Well, let me ask you this.
Yes, Your Honor.
If Mr. Union had stolen that $7,500 from the account, he would have directly received a benefit for something that he wasn't entitled to, right?
Correct.
But in this case, the Riverbend bill was incurred because of Ms. Miller's independent need for nursing home care, wasn't it?
Yes, it was, Your Honor.
So the bill was legitimately assessed against Mrs. Miller, correct?
That's correct, Your Honor. However, what happened here is also that there was a direct loss to the nursing home facility through the criminal act, which was the misappropriation. So it wasn't really just a lack of payment, but it really was the crux of the criminal action here, which was a misuse of money against Ms. Miller.
What evidence do you have that the nursing home has lost that money?
The record indicates that a couple of things, Your Honor. The first being that Mr. Union was the person that was obligated to pay the bills. Secondly, he's the one that had access to that money. He actually did pay a couple of months to the nursing home facility, and then he didn't.
Has her other creditors also lost money because of Mr. Union's crime of conviction?
I'm not sure to which creditors would have kind of asserted that claim. I believe that the nursing home facility was the most relevant one because she was living there from the years of 2016 to 2017. And this was at the same time that Mr. Union had access to her. Perhaps there were other creditors, but this seemed to be the most pertinent one because of Mr. Union's sole obligation to pay for that.
Is there any evidence that either Ms. Miller had to pay more interest for her stay at Riverbend, or that Riverbend lost interest or lost investment because the bill remains unpaid?
In terms of interest, Your Honor, I'm not sure what the record would indicate as far as interest lost. However, our position would be that there was a direct economic loss when they didn't receive the money, but they still provided the services to Ms. Miller.
Mr. Moya, I think the crux of the argument, Mr. Hodgson's argument, is causation.
Yes, Your Honor.
Okay, so when we're looking at the causation, the defendant's crime was he stole money, right? So stealing that money from the victim, how did that cause Riverbend to suffer a $7,000 loss?
The reason is because it's a chain of events. It's a causation through proximate cause. It wasn't directly that Mr. Union caused this, but as this court has stated in State v. Arnett, it can be a chain of events. What happened here is that he's been in control, Mr. Union has been in control of the money for years. Ms. Miller couldn't pay. She needed to be in the nursing home. She was not using that money. So through the misappropriation of those funds, the money was not being used in the place that it needed to be.
Could there be other reasons why Mr. Union didn't pay that bill? For example, in the record, there is evidence that he the defendant didn't pay because there was an added charge that he didn't understand. In the record, he said that's the reason he stopped paying. So if that was the reason he stopped paying, then the causation falls apart, right?
Perhaps, Your Honor, but separate from the added interest, it's also worth pointing in the record that the payments in general stopped. So it wasn't just because of the added interest, there was no further payment to the nursing home
But
facility.
how is that connected to him taking money from her?
It's connected because,
He
it-
made a decision not to
Yes.
pay, but how is his decision not to pay connected to his crime to take money from her?
it's connected because there is a reliance that happened here. The reliance being that Miss Miller could not do it. She's the one that's the person responsible to the nursing home facility. But the person, the guarantor for the nursing home facility is Mr. Union.
Right, but wouldn't that be, if he's the guarantor, wouldn't that be a civil claim that the nursing home has against the guarantor?
And I think that goes back to what I was referencing through the statute that controls here, which is that it shall not be limited to, but will include damage or loss caused by the
Caused by, there's that caused by.
defendant's crime. Would argue it is, Your Honor. I think that there is a chain of events happening here. So that would be. my
What was
response to
the
that.
evidence in the record about the status of the bill? Did it ever get paid?
That part, going through the district court record, it was unclear what ultimately was paid, but the restitution, the amount owed to the nursing home facility was what was ordered. So at least
Oh, but
there was.
The bill was paid.
Oh,
That, what I heard you just say, that the bill was paid?
no, there was an amount that was unpaid, the 7,600.
And that was, there was evidence of that?
There was the money owed to Nursing Riverbend. Yes, there was evidence that that money was still outstanding for the nursing home facility.
And was there any evidence as to why it wasn't paid?
The evidence that the court relied on was the overall misappropriation and the statements in the court from both Mr. Union and the adult services
Well, I guess I'll just cut to
investigator.
the chase. Was there any suggestion or do you know whether the estate just didn't pay it because there was a hope that this was going to be ordered as restitution?
I don't see any evidence for that, Your Honor. I do see
Just
evidence.
don't know why the estate didn't pay the bill.
Well, Ms. Miller, at that point, I guess factually, at one point, she was not in control of her estate, and then she subsequently died. So she would not have retaken the control and then paid back the estate. So it's still a debt outstanding in general.
Mr. Moy, I want to move you to the second argument, which is just in general, kind of a scary thing to think about, which is if somebody embezzles cash, of course, the state is in a position that they can't prove how the defendant spent it.
Right.
So it's very difficult to show that they did not spend it to care for the victim in this case. So what are we supposed to do with that? Because the burden is on the state to prove that it was misappropriated and it was all cash.
And yes, Justice Standridge, I don't disagree with that burden. What I would say is that there isn't a burden shift here. The district court did rely on evidence. What happened here is that, as stated, there was testimony from the Adult Protective Services investigator. That investigator brought receipts, bank account statements from Mrs. Miller, and the subsequent times that cash was withdrawn.
How is that, what, because I understand that there's circumstantial evidence that you can use circumstantial evidence. What was that circumstantial evidence that showed that this money that was withdrawn did not go to benefit Ms. Miller?
I think the most poignant point to that is that Ms. Miller was in the nursing home facility when a lot of these transactions happened. And I think that's perhaps understated in the record. Ms. Miller's facility was taking care of her housing, of her food, of her medical situation. Yet despite this, the ATM withdrawals continued. So there is circumstantial evidence that money was being withdrawn and that money was likely being misappropriated. I think it's important to couple that with the uncontested restitution claims in this case. As stated, there are withdrawals for liquor store, there are withdrawals for Men's Warehouse, for Walmart, for dating websites, and so on, that had not been related with the ATM withdrawals, but coupled together, there is an inference, a reasonable one, that the ATM withdrawals, especially when Ms. Miller was at the nursing home facility, was being misappropriated.
The judge also made a direct finding that he did not find Union's testimony to be particularly credible.
That's correct, Your Honor. To that point, I would state that the district court did use substantial competent evidence here in the term of direct evidence through the exhibits and the bank accounts in terms of circumstantial evidence when coupling the other types of withdrawals. But really, as stated in the state's brief as well, arguably what's happening here is asking the court to reweigh the credibility or the evidence that had been introduced. I think that perhaps that's a better articulation of what's happening here. As the state brief citing State v. Benecourt, an appellate court does not reweigh the evidence. They or assess witness credibility or resolve conflicting evidence. And that's really what's happening here. It's not an argument about whether or not evidence was actually used. It's an argument of whether or not that evidence was credible or sufficient. But our position is that it was, that there was enough testimony and enough exhibits to contend that the money was essentially misappropriated. Yeah. In terms of this issue with the ATM withdrawals, I believe one of the arguments that has been put on appeal is whether this is a situation where the baby had been split, whether it was done arbitrarily. However, there was essentially a determination from the court whether that decision, whether the amount of restitution was fair. The district court said that it was essentially generally low what they had requested in this case, that despite the thousands of dollars that could have been ordered against Mr. Union, only $23,878 was actually ordered against Mr. Union in this case. Which again, I believe that there was evidence to state that that was more than a fair number, given the evidence that was presented at the restitution hearing. And if the court does not have any questions, I would like to thank you.
Justice Rosen, I just wanted to rise to respond. I've looked and I haven't found, just sitting here, that certainly in the order and restitution that I have, I don't have an interest. In any case, to the extent that the district court tied that to any civil judgment, the civil judgment was set aside by the Court of Appeals in this case, pursuant to this court's Arnett decision. So I'll continue to look at that. My last thing is in response to my colleague's argument that he sort of takes on the Court of Appeals argument here. It's interesting to me that the Court of Appeals recognized, and my colleague recognized, that the Court of Appeals isn't supposed to be a fact-finding court. It's supposed to be reviewing, and here the Court of Appeals affirmed this, finding, as my colleague has argued here today, well, look, the amounts being taken out were the same during the time that the adult was in the nursing home, and you know, that's evidence that this was all being used for bad purposes or things like that. You know who didn't find that? The district court. The district court found you committed a bad, dishonest act. You can't prove you didn't spend that on yourself. Therefore, I'm making this holding.
Well, I'm going to push back on that a little bit, because if you have a finding that you, Mr. Union, lack credibility based on these other things that have been proven, like the dating website, the liquor store purchases when Ms. Miller didn't drink, I find that you're not a credible witness. Now, can't that be combined with the understanding that you've got an incentive now as someone that I believe to be dishonest, not to keep receipts? Because if there were receipts, then we would be able to see what's been spent for Ms. Miller and what's been spent for you. But if the position is that the state can't prove that I stole it, so you can't prove that I stole anything, even though it's cash that has disappeared. And during a time when Ms. Miller was in the nursing home. Doesn't that incentive, combined with the finding of lack of honesty or lack of credibility, combined with large amounts of cash that simply have disappeared into the ether, doesn't that leave the court with the ability to make factual inferences from those things, that a good portion of that went to Mr. Union's personal expenses inappropriately?
Your Honor, I'm running out of time. Can I answer the question?
That was a long question. I'm sorry.
So I think the district court did make a found that my client was incredible, but that's not evidence against my client. I mean, I don't believe your evidence, right? My client's entitled to put on evidence, and he did, and the district court said, I don't believe that. Okay, but that doesn't mean that the state still doesn't have to put on affirmative evidence of the particular finding in this case, which is, were these particular, or in some aggregate way, these expenditures for the benefit of Mr. Union, for the benefit of the adult, or something else in this case. And that's the problem here, is just because you don't believe my client, okay, still have to look at the record and say, what evidence did the state put on to show that these things, and the state's own expert said, I can't tell you where these things went. That's the problem. Your Honor, sometimes we hear the adage, it's close enough for government work. And I guess the question is finding close enough for a restitution holding. This case, this court in Smith seems to say that a defensible restitution amount has to be based on evidence, not based on the lack of the defendant's evidence. Thank you.
Can I real quick jump in at the very end and just ask if you have a sense from the record as to why the nursing home bill was not paid?
No, I mean, we don't have sort of what happened with the estate. That's where we would do that, right? We could do that in the estate and assess appropriate civil judgment against Mr. Union if that's appropriate. Thank you, Your Honor.
Thank you to both counsel for your arguments. The court will take this appeal under advisement.